Are you taking the solicitor's qualifying examination? If so, this video is a practice test to help you prepare for the SQE1 exam. The topic tested in this video is the right of audience. I will explain what you need to know about the subject in these easy to learn diagrams. If you want to get access to the first part of our full SQE preparation course for free, just click on the link below. My goal is to help you prepare for and pass the SQE examination first time. At the end of this video, we'll go through this practice test question together for this topic. When a solicitor qualifies, they have a right of audience to appear in the inferior courts of England and Wales, i.e. the county court and the magistrates court. When a barrister qualifies, they have the right of audience to appear in both the inferior and superior courts, that is the High Court, Crown Court and Court of Appeal and Supreme Court. However, after qualifying, solicitors may take a further qualification to be a higher courts advocate, which allows them the right to appear in the superior courts as well. A right of audience is defined by the Courts and Legal Services Act 1990 as the right to appear before and address a court, including the right to call and examine witnesses. Under this act, one must be authorized or exempt in order to exercise a right of audience. It makes it an offence to do so without authorization. Various approved regulators are entitled to authorize people to exercise rights of audience. These include the Law Society, the General Counsel of the Bar, the Institute of Legal Executives, the Chartered Institute of Patent Attorneys, the Institute of Trademark Attorneys, and the Association of Law Costs Draftsmen. A so-called litigant in person is someone representing themselves in legal proceedings without assistance of an authorized representative. Litigants in person may seek the assistance of a non-authorized individual and appoint one as a so-called McKenzie Friend. A McKenzie Friend is different from an authorized representative because they have no right of audience. So a litigant who is assisted by a McKenzie Friend will remain a litigant in person. A McKenzie Friend may provide moral support for litigants, take notes, help with case papers, and quietly give advice on any aspect of the conduct of the case. A McKenzie Friend may not, however, address the court, make oral submissions or examine witnesses or otherwise conduct litigation. In exceptional circumstances, a court may permit a McKenzie Friend to address the court. Such circumstances will be rare, and this is not the same as having a right of audience. They may not receive any payment for their services, and they may not act as the litigant's agent in relation to proceedings. They can't manage litigants' cases outside of the court, for example, by signing court documents. The judge has the discretion to refuse to permit a litigant the assistance of a McKenzie Friend if the court is satisfied that the interests of justice and fairness do not require any such assistance. The court may also withdraw permission for the assistance of a McKenzie Friend if the administration of justice is being impeded. Here is a sample question of the kind that you could get in the SQE1 exam on this topic. You qualify as a solicitor and wish to develop an appellate practice as an advocate in the Court of Appeal matters. Is this possible? A. Yes, but only if you first qualify as a higher courts advocate. B. No, the only way to achieve this would be to cross-qualify as a barrister. C. No, your clients would have to represent themselves in the Court of Appeal and you could only have an advisory role. D. Yes, but you would need to act as a McKenzie Friend. The answer is A. Yes, but only if you first qualify as a higher courts advocate. I hope you found this helpful. To get the first part of our full SQE preparation course for free, just click on the link below. See you in the course.